Good evening. I'd like to welcome everybody to the March 5th, 2024 meeting of the Milford Planning and Zoning Board. If we could please stand for the pledge and a moment of silence. Thank you. Meg, if you could please call the roll.
Mr. Mortimer is excused. Mr. Agnesi?
Present.
Mr. Alling?
Present.
Mr. Anderson?
Present.
Mr. Hirsch?
Here.
Mr. Collegian?
Present.
Mr. Macchio?
Here.
Mr. Sadi?
Present.
Mr. Zacharidis?
Present.
And Chairman Quish.
I'm also present. Just a little bit of housekeeping. We're going to reorder the schedule. It looks like 104 Edgewater may take longer than the other two applicants. So what we're going to do is we're going to hear 69 Melbourne Street first. We're going to hear 277 West Avenue second, and then 104 Edgewater. So the applicant for 69 Melba has the floor. Yeah, and one more thing, that microphone doesn't work. If you wouldn't mind, just relax, have a seat over there, and we'll all be able to hear you. Thank you. And also just push the button.
To speak. Next time, this is the second time I've been here. The third time will be the charm, and I'll get it right. Mr. Chairman, members of the commission, my name is Tony DeNorfia. I'm a principal of a construction company called A. DeNorfia Building and Development, LLC, with our offices at 133 Main Street, Southington. We've been home builders and developers for in excess of 40 years. The applicant, who happens to be my wife, and I were very fortunate. Approximately 5 years ago, we purchased the property directly across the street from this at 70 Melba Street. I don't know if you're aware, I'm sure you're aware, but the history on that piece was it burned in a fire a couple of years prior to that, and then we redeveloped it. When this property became available right on the water, obviously we jumped at the site at the chance. The subject site at 69 Melba Street consists of a single-family home built in the early part of the last century. I'm sure it was built as a cottage and it was converted to a year-round residence. The lot is deeded as roughly 40 by 120 feet. It's rectangular, bonded north on Melba, south on the Long Island Sound, east by a vacant parcel of land, and west by a single-family seasonal cottage. The home is built right up to the seawall and right up to the property. When we started to design this house, we had one direction, and that was we wanted to meet all of the requirements of the regulations. So in this application, we never applied for any variances or anything along that matter. As it is, we meet all of the requirements of the zoning regulations as far as the setbacks. The side yards, as you're aware, are 5 and 15 feet. We're slightly bigger than that. The rear yard along Long Island Sound, not taking into account the possibility that we could have gone right up to the wall, is 20 feet. We maintain 22 feet from the closest deck. We're 34 feet to the home. The front yard is also in excess. We're at 37 feet along the front yard. As far as the building height, we're allowed to go up to 35 feet. As you know, we have to be above the flood elevation, so the home measures at 34 feet, so we're below that also. We provided the on-site drainage by stone infiltrators on either side of the property that will be, either side of the home, that will be connected to the downspouts. We've read all the reports and have extensive give and take with your town professionals, the zoning enforcement officer, the town engineer, and the wetlands officer. And we have no problem with any of them, and our intention is to meet all of your regulations. Our design professional is also here, Jim Sakonchik, an engineer surveyor from Kratzer & Jones. If you have any questions, we'd be more than happy to answer them.
Thank you. Would he like to do a presentation prior to questions, or would you like us to just go into questions?
No, I think we can go right to questions.
Okay, thank you. Okay, is there any, David, if you'd like to, please weigh in.
The applicant is proposing to construct a new single-family dwelling of 34 feet in height. The proposed plans appear to be substantially zoning compliant, but the house plan is required to be updated to be in compliance with the building code. No adverse impacts to coastal resources are anticipated.
Thank you. Any questions or comments from the board? Seeing none, I'd hear a motion. Oh, this is just a public hearing? No, it is not. Okay. Sorry about that. Mr. Sadi.
Thank you very much, Chairman Quish. Regarding 69 Melba Street, Zone R5, I move to approve as presented the petition of Anthony DeNorfia for a coastal site plan review to construct a single-family dwelling on map 29, block 587, parcel 24 of which Deborah DeNorfia is the owner.
Second.
We have a motion and a second. Do we have discussion on the motion? Seeing none, if you would please call the roll, Meg.
Mr. Agnesi,
With the motion.
Mr. Allen,
With the motion.
Mr. Anderson,
With the motion.
Mr. Hirsch,
With the motion.
Mr. Collegian,
With the motion.
Mr. Macchio,
With the motion.
Mr. Sadi,
With the motion.
Mr. Zaharidis,
With the motion.
and Chairman Quish.
With the motion. Good luck with your house.
Thank you very much.
Next order of business is 277 West Avenue, Zone R12.5, petition of Thomas Lynch Esquire for Reeves subdivision to create a second building lot at map 032, block 336, parcel 8, of which Custom Homes and Improvements LLC is the owner. Applicant has the floor.
Yes, thank you, Mr. Chairman. And just for the record, Thomas Lynch, I'm an attorney with the law firm Lynch, Trimbicky, and Boynton, and my office is located here in Milford at 63 Cherry Street. And I wanted to start by thanking you for juggling the arrangement of the agenda so that we could make this presentation. It's a pretty straightforward presentation to you. I'm here tonight with my client, Brian Coddington. Brian is the owner of the property, 277 West Avenue. He purchased the property about 2 years ago. And this parcel is the remaining parcel from a 1961 subdivision known as Garden View Acres, where the homes were developed on Collinsdale Avenue. If you review the map, you can see the existing house with the driveway coming off of West Avenue. I believe that may be the next sheet, David. the proposed subdivision. So the house at 277 West Avenue has the driveway coming in off of West. The new house will be actually on Collingsdale Avenue, and the driveway coming in off of Collingsdale. HKA Associates of Trumbull did the engineering work associated with this, because Mr. Plain is not an engineer. The two structures as laid out will both be zoning compliant as it relates to setbacks and lot coverage and building coverage. The plans also have a utility plan showing the sewer lateral on Collinsdale, which will be utilized to service the house. We did receive approval from the sewer commission for the sewer hookup, so that's part of the documents on your agenda tonight. The gas line on Collingsdale will also be accessed for the new house. And then lastly, there'll be overhead utilities bringing the power from the existing utility lines on Collingsdale to the house. The plans were reviewed by all the city departments. As I said, the sewer commission issued an approval for the second house. You have a report from Sergeant Kraniak of the traffic division of the police department stating that he's reviewed the plans. The sight lines are fine for the access to the second house. There's enough of a setback from the intersection that it poses no public health or safety issue. The fire department has also approved the plans. And then lastly, there's a report to you from the city engineer, Greg Podleski. That letter that you see on the agenda is a revised memo. He had made a review with some revisions that he wanted to see on the plans. The plans were revised and submitted so that his memo that you have now basically has approved everything. We're still waiting for stormwater calculations for the entire parcel. HKA Associates had done a stormwater retention calculation based on the new lot, and Greg said he wanted to see a calculation based on the entire property. So that's being done, and I believe David even noted in his memo that any approval motion be subject to acceptable report to the city engineer for the stormwater mitigation. That's about it. We will be submitting an appraisal. The board sees fit to approve this application prior to the filing of the map on the land records. Per your subdivision regulations, we will be getting an appraisal to submit to David for a calculation of the 10% open space contribution, which will be made in this case. And unless you have any other questions, that's the extent of our presentation. Thanks.
Thank you. David, if you would start by explaining why the re-subdivision comes in front of us, and then whatever you want to chime in on.
The re-subdivision comes to you because it is done under the subdivision regulations, which are under you. Anytime a new lot is created or there are changes made to its configuration, depending on what the situation is, it comes to the full board.
Thank you.
You're welcome.
Anything else you'd like to weigh in on?
Yeah, and before I read my report, Mr. Lynch, I missed in your reviewing your plans one very important part of the subdivision regulations, which requires all utilities to be underground. That includes electrical, which I missed. So
then the plans will be revised to comply with that, and that can be made a condition of approval as well.
very good.
Yep.
Thank you.
Thanks.
In that case, I can read my report. The applicant is proposing to re-subdivide his property into two R12.5 zoning compliant lots. The existing house will remain on Lot A, and the proposed zoning compliant house is shown on Lot B. The proposed re-subdivision is compliant with both the subdivision and zoning regulations once the electrical is placed underground, which will be made a condition of approval. A fee in lieu of open space to be determined in accordance with Section 3.10.1 is required prior to the filing of the re-subdivision Mylar. Approval should be conditioned on submittal of a stormwater mitigation and treatment plan as specified by the city engineer in his letter dated 3/1/24.
Thank you. Are there any questions of the applicant? Mr. Sadi?
Thank you very much, Mr. Chair, and through you. And just for statement purposes, for those in the public, you'll see most of the board members have some sort of electronic device with them. Instead of paper, we're reading all these different things. So just want to let you know we're not just looking at emails, we're looking at the documents. I think one of the conditions also is that the fee in lieu of open space, just briefly explain that, Mr. Attorney Lynch, because we get several new board members up here also.
Sure. So under our subdivision I was going to say David could do it, but I can do it too. Under our subdivision regulations, whenever a subdivision is approved, you have an option. You have to dedicate a certain area. David, is it 10%?
Yeah, 10%
10% of the area as usable, very important word, usable open space. In other words, something that can be dedicated for use for the public for recreation, a playscape, something of that nature, and open to the public. In lieu of that, because this is, going to be just 2 residences and it's not that large of a parcel of property, the regulations also allow for the applicant to submit a contribution to the open space fee that the city maintains to purchase open space, and it's based on a calculation of 10% of the value of the land that's divided from the property.
Thank you very much.
Okay, before we open up the public hearing, is there any other questions? Go ahead, Brian.
Through you, Mr. Chairman, to Attorney Lynch. Tom, I'm wondering about the gas company cut. Will that occur before the street's paved or not?
Well, the street is paved. So in other words, you're talking about the gas line that's going to service the house?
Tom, it's been milled and it will be paved.
I haven't driven down there. Is it milled?
It's a paved road.
Right, but what Brian's saying is it must be in the process of being done.
That's correct.
That's a good question. It probably would make sense to put the gas line in before it gets paved. So I will suggest to Brian to work that out with Chris Saley to arrange for that. I haven't driven down there, Brian, so I wasn't aware that that was going on.
Ideally, that would be
Yeah,
the case.
absolutely. Yep.
Thank you.
Yep.
Any other questions or comments before we open the public hearing? Okay, this is a public hearing. If anyone would like to speak to this matter, please, you can sit over on that side and the microphones work over there. Going once, going twice, seeing none, we'll close the public hearing. And if there's no further questions or comments, I'd hear a motion. Go ahead.
Thank you, Mr. Chair. I make a motion regarding 277 West Avenue Zone R125 to approve with the following modifications. Petition of Thomas Lynch, Esquire, for re-subdivision to create a second building lot at map 032, block 336, parcel 8, with Customs Home Improvements LLC as the owner. The proposed conditions of approval will be the applicant shall make a payment in lieu of the open space donation. The applicant shall submit a stormwater drainage plan that is satisfactory to the city engineer. And 3, to follow the appropriate regulations and codes regarding utilities.
We have a motion. Do we have a second?
Mr. Chair,
Yep.
can we get the motion amended to specifically say the installation of underground electrical utilities?
You okay with that, Mr. Sadi?
Certainly.
Okay, and we have Mark as seconded. Is there any further discussion on the motion? Seeing none, Meg, if you would call the roll.
Mr. Agnesi,
With the motion.
Mr. Alling,
With the motion.
Mr. Anderson,
With the motion.
Mr. Hirsch,
With the motion.
Mr. Collegian,
With the motion.
Mr. Macchio,
Against the motion.
Mr. Sadi,
With the motion.
Mr. Zaharidis,
With the motion.
and Chairman Quish.
I am with the motion also. Good luck with your project. Okay, the next order of business is 104 Edgewater Place, Zone R12-5, petition of Kevin Crusading Esquire for a coastal site plan review to construct a single-family dwelling on map 045, block 513, parcel 39, of which Brenton C. Arts is the owner. This has been continued from 2/20/24. The applicant has the floor.
Good evening, Mr. Chairman, members of the Commission. For the record, my name is Kevin Crusading, an attorney with Crusading & Moore, 3 Lafayette Street here in Milford. With me this evening is John Wicko, architect on the project, Ron Wasmer, PE, professional engineer. He's the engineer on the project, and we also have Alex Voyitek from our William Kenny Associates, who assisted us through the wetlands approval with the soil testing. My clients, due to other previously arranged travel plans, couldn't be here tonight. I usually don't talk too much on these. There's been a couple of legal issues that have come up, so I'm going to address those. Then I'll turn it over to probably Ron Wasmer to go over the CAM application, and then John Wicko, and our soil scientist is here to answer any questions. So we started this in this process in the spring or summer of 2023. First discussed it with David, and then because there is inland wetlands, within the upland review area, actually in the city right-of-way, we went through the inland wetlands process. I've done a lot of these coastal site plan applications as the attorney for them. The board sees a lot. I think you saw 3 or 4 last month. You just approved 1 single-family house on the water tonight at 69 Melba Street. The history of this zone, originally it was, or this property, originally it was in an A residence zone. It actually was established by a subdivision map that was pre-year 1929 subdivision regulations. Over time, the regulations have changed, and both the subdivision and the zoning regulations have changed. This lot is considered a legal pre-existing non-conforming lot due to size, and that's allowed specifically under the zoning regulations, and a lot of case law in Connecticut discusses that, but what's important is how Milford handles these cases. So with this case, there was Attorney Green, and I believe his partner, Attorney Lasky, is here this evening, had raised the issue that this is 5, 10-foot subdivision lots, and therefore it's not a proper building lot. That's not how Milford treats the old subdivision lots. The old subdivision lots can either be consolidated by a lot consolidation map, and there was a map filed in the land records, AB, I think it's 2579 or 2879, but it's in the volume of material that I had previously provided to the board, showing it as 1 lot, and that was in, I think, 2004. Also, lots can merge, which you're familiar with. Usually it's, 2 or 3 smaller lots that are forced to merge by your previous 642 and now your existing 642, and that's what happened in this case. These owners purchased it in, I think, 04, 06. They've received building permits for a gazebo. It's kind of like a 2 or 3 season, I think it's on a cement pad that crosses all 4 out of the 5 of the subdivision lots. So that was merged, these lots were merged into 1 building lot, at least back then, probably far prior to it. So I think that, David and I historically don't always agree on a lot of different things, but in this particular case, David agrees, and before we started this whole process, before I got the other design professionals involved, I went to David and I talked to him and I said, how would you view this lot? We looked at the lot map that showed it as 1 lot. We looked at, and that was, the decision was, yes, this is a legal building lot at that time. So there's no other steps that need to be taken in the Milford zoning regulations. The argument, respectfully, that Attorney Green's making is an argument almost as if you were looking for a lot certification, or I was trying to get an undersized lot approved or separated, or for it not to be merged. So it's almost the inverse argument that you've heard over the years when 642 was eliminated from the regulations. But the issue of whether it's a building lot was settled at least 20 years ago, if not more, and it's map AB 2927, and that was in 2004. Also, in April of 2022, almost 2 years ago now, this board approved an application for 94 Edgewater, which is the property immediately next door. That was a similar situation. It was 4 old subdivision lots. The property was 40 feet wide. That didn't even have a permanent or a semi-permanent structure on it. It had the docks, but it didn't have anything merging it. But that was also determined because it also had a map filed around the same time in 2004 that was a pre-existing, legal pre-existing non-conforming building lot. So this board's already made the decision that those lots from that subdivision map can be consolidated. And you don't even need to look at 94 Edgewater to make the decision on this. It's how Milford has treated these lots over time and how Milford interprets its own zoning regulations. So when you're tonight, especially for some of the newer members, if you're not familiar with the CAM process, and I know you probably already have heard 5 or 6 of them on your short time on the board at least, but what you're looking at as far as you're required by state statute to determine whether the application is in conformance with the zoning regulations, number 1, and then number 2, you look and see whether it's in conformance with the Coastal Area Management Act. And in this particular case, we have done all of the due diligence and gone through the process, like I said, going back probably 8 or 9 months, to make sure that we take into account the city engineer's requests. John Goucher from DEEP, who is one of the individuals responsible for overseeing the Milford area, he has agreed that this plan and project he has no issues with it, that it's in compliance with the CAM Act. Mr. Sulkus agrees that it's zoning compliant, and his memo, I think, says that there's no adverse coastal impacts anticipated. Stephen Harris has reviewed this, the zoning enforcement officer, in December of this past year, and he's determined that the project is zoning compliant. Greg Podlisky, the city engineer, has accepted the drainage plan after some revisions back and forth with Mr. Wassmer. Some of the CAM claims that have been brought up talk about scenic views and vistas, no non-water dependent use on the site, degrading natural erosion patterns in violation of this, certain aspects of the CAM Act, degrade drainage patterns, but there's no evidence to support that, first of all. Secondly, when you're talking about degrading visual views and vistas, you're talking that the CAM Act is designed and it's envisioned and it's been interpreted, and I think properly, that's public views or vistas of an existing natural resource. Like, for example, if you were going to build on a dune, or there was going to be a large project out on Charles Island that the public was going to view and have an issue with. Those are the types of things that the CAM Act is designed to address. And so it's not a view of one person from their property, down the street or to the harbor. It also, there's case law that I've put in the my memo that I had filed last month that talks about, developed harbors and things of those nature, things along those lines. So this is not a pristine property. If you had an opportunity to look at some of the photos that were filed, whether it was from Attorney Green's office or my office, there's some drone footage or photos, there's some Google Earth photos. It shows a fully developed harbor, fully developed shoreline, houses, there's commercial fishing, one or two properties away from this one. There's a single family house next door. There's a property on the other side that's got a full in-the-ground pool and an outdoor, cement outdoor oven. Then there's Spencer's Marina, and then further down, there's another house on the harbor. So it's a developed area, and those who are familiar with Milford Harbor know that it's fairly developed, if not fully developed to the maximum. So I just want to run through these other points to make sure I didn't miss anything. I know you have the memo and you can read it. You've had it for a couple of weeks now. It's also been uploaded to the city website. Currently, I think it's important to note, and Mr. Wasserman will go over it, there's no stormwater treatment currently on the current property. There's several different structures, but that's because there was nothing required to be. Also, the structures that are on the property now are not FEMA flood zone compliant. A house, if approved, would be required to be FEMA flood zone compliant and elevated to the proper building codes and flood hazard codes. Like I said, the city engineer determined the application consistent with CAM and compliant with the deep recommendations. I mean, Mr. Podolsky, I think there's 4 reports: September 2023, November 2023, December 2023, and then January of 2024, where there's been reviews. The earlier September review by the city engineer was in conjunction with the inland wetlands application because we were required to go to them first. That was also reviewed by that agency, and they approved this project. A side note, it's not completely dispositive, but it is indicative. An address has been assigned to the property since at least June of 2004. The significance for me and my experience with that is that typically if something's not a building lot, it has a 0 address, but this address was assigned to this property, this 104 Edgewater. That's not always true. And speaking with David, I thought that would probably be ultimately true. Typically, if there's a 0 address and you get a lot approved, then Mr. Harris assigns it a new address. But this has had an address since that point in time. It's had previous inland wetland approvals for a driveway. It's had a previous inland wetland approval for the cabana or the gazebo that's the semi-permanent or permanent structure that's on there. It's had previous zoning permits and building permits issued for this, not just for the docks. The idea that these properties were originally created as dock lots or to go with the associate subdivision where the houses are, that could be true, but that doesn't stop the use or the allowed use to be changed from what was back then to what is now. You could have combined 5 or 6 of those lots back then and built a house on it. For whatever reason, that just wasn't done. I would like to point out also that the other houses in this very subdivision are on properties that consist of 3 or 4 different lots. So if you're going to take the argument that you can't build a house on this lot because it's comprised of 5 original small subdivision lots, then the same argument, should have applied to those houses before they were built. The legal argument that Attorney Green makes has almost would keep this property in a permanent state of 5 10-foot wide lots, which is not how the Milford zoning regulations or subdivision regulations or Connecticut state law treats these. They want to move towards a more conforming lot, but we're not doing a new subdivision. You did a re-subdivision tonight. We're not doing that. So we don't have to comply with the minimum lot square footage, which in this case is an R12-5 zone. But it's important also to point out that this is a residential zone. And when you really look at what we're asking for, it's a single-family house in a single-family zone in a single-family neighborhood on a single-family building lot. That's basically as simple as it is. The reason Usually, single-family houses are exempt from the CAM Act, but if you're within a certain distance of a coastal resource, like we are, or 69 Melba Street was earlier tonight, then you're required to come to the Planning and Zoning Board, who acts in an administrative capacity versus your legislative capacity if you were doing a zone text amendment, for example, where you have some discretion about whether you feel something should be approved or changed or not. In this case, your obligation is to look at the application and see if it complies with the zoning regulations and with the coastal site plan regulation. And it's a site plan application. The board decided to grant a public hearing in this case, which is why we're here tonight. There is a lot of other case law and other supporting documentation that I did submit. I'm not going to go over all of it. Maybe in a rebuttal at some point tonight, I would go over that. But I think you get my point that the property is 100% zoning compliant as agreed upon by all of the local Milford officials. And there's no variance required. I think that was another argument. And there's no shown adverse impacts to coastal resources in this case. So one other thing, there was a referral to the Harbor Management Commission, which is not part of the CAM statute, but it's part of a different statute. And the Harbor Management Commission reviews these applications to see whether they're consistent with the Harbor Management Plan. That is being reviewed by the Harbor Management Commission. They've had it now, the plans, for a week or so ago. I think February 21st they were given those plans. So their next meeting is March 21st, I believe. And we're anticipating a favorable review because there's nothing that is inconsistent with the Harbor Management Plan as far as this application goes. They're more concerned with dock placeage and waterways and other things like that. So before I turn it over to Mr. Wassmer to go over the actual application, does anybody have any questions for me?
Go ahead. Excuse me, go ahead.
Thank you, Mr. Chair. Through you to Attorney Crusade. Your first hearing on this matter was February 6th. And when did you finalize your application such that it was able to get on a public hearing?
We finalized the application prior to February 6th, so we would have had to finalize it before David led it on the agenda, before Mr. Sulkus led it on the agenda. So the materials I've filed since that point in time, Mr. Sadi, are in response to Attorney Green's filings.
I'll get to that in a minute. And then we've had the continuance to the 20th, correct?
At the first meeting, the board decided to have a public hearing, so we couldn't go forward that night. Then because the public hearing hadn't been noticed. So then we went to the 20th.
Then we're here tonight, correct?
What's that?
We're here tonight on the first continuance. So the 6th to the 20th to this date.
Well,
Mr. Chair?
we're not really here on a continuance. We're here as,
Yeah, go ahead, David, if you'd like to try to clarify that.
The public hearing officially opened at the last meeting. That's what the board needs to know. The public hearing officially opened at the last meeting. This is the continuance of that public hearing.
Thank you. But so prior to February 6th, you had communication with Attorney Green by communications, and we got it before the February 6th hearing that they were going to be an intervener, correct?
well, they did it. They had filed an intervener petition, which they withdrew. Yes.
And when did this Milford, I think you said the Milford Harbor Commission, when did this come into the mix?
David had called me about it probably on February 20th or 21st. It's a separate.
Just looking for the dates. Just looking for the dates.
February 20th or 21st.
Okay. And did you receive a letter dated March 1st of 2024 from Attorney Lasky on behalf of Attorney Green regarding the Milford Harbor Commission?
I did.
Okay. Now, I've read your 135 pages, and I really appreciate that, but I do see that one of the cases you pointed out for us, which is actually something against the Milford Planning Board, indicates that we have a discretion to have the public hearing.
Yes.
So we're here, and originally I voted against that, but thank you for helping me out on finding out that I was probably erroneous. But you also indicated to us that our responsibility here on a CAM application, just would you repeat that, please, just to make which findings?
So your responsibility as a planning and zoning board pursuant to the state statute on a CAM application, you have two. One is to determine whether the application is compliant with your zoning regulations. And two is to determine whether the application is compliant with the Coastal Area Management Act.
And the last question I have for you is, you talked about, if you're looking from the property towards the water, you're talking about to the right, there's 94 Edgewater, there's a piece of property that has a pool and other things, and there's a marina. But to the left, there's also another property that's right on the water, and then, and it's, I think, 30 Edgewater Place.
I think 30 Edgewater Place is a house a little bit further down.
Correct.
Yeah.
And do you know if that's part of this subdivision that started off in?
I don't believe 30 Edgewater Place is.
Okay.
I believe some of the other lots might be, are part of this original subdivision.
And do you know if 30 Edgewater Place has a dock on it also?
It has a couple of docks.
Okay. At this point, Mr. Chair, I have no further questions of Attorney Crisaden. Thank you very much, sir.
Thank you.
Thank you. Is there any other questions for Attorney Crisaden before we go to David and then into the public hearing? Oh, no, we're going to go to Mr. Wasserman first, right? Applicant still has the floor.
Yes, thank
Yeah,
you.
that's right. Thank you.
Good evening. For the record, Ronald Wasmer, professional engineer and land surveyor with an office at 158 Research Drive, Milford, Connecticut, here representing Brenton Arts, the property owner for a coastal site plan application at 104 Edgewater Lane. My role as part of this team in submitting this application is the surveyor in preparing the existing condition surveys as a basis for the site plan and as the site engineer to prepare site engineering in regards to stormwater management, utility location, erosion control plans. I also assisted in preparing the coastal site plan application. I'd like to briefly walk you through the application and the plans. Starting with the application for a coastal site plan is somewhat more detailed than your typical application for a site plan. It's some 11 pages long. I'll try to summarize this as quickly and as briefly as possible. The type of project is a single-family residence. The coastal resources located within the property or which the property will affect are the general resource that are on the property or adjacent to the property are the general resource, tidal wetlands. There's approximately 59 square feet on site and additional tidal wetlands adjacent to the property. The property is in a coastal flood hazard. The parcel is located within flood hazard zone AE11. Adjacent is coastal waters, that is the Milford Harbor. Additional resources is a developed shorefront. The parcel is designated on the coastal resource map as developed shorefront. Freshwater wetlands are adjacent to the property and fall within the municipal right-of-way of Edgewater Place. In section number 1, the applicant identification, the applicant is Brenton C. Arts of 9 Nair Lane. Section 2, project site plans. The plan contains the information requested in the application, section 2. This includes project location, existing and proposed conditions, including building and grading, coastal resources on and contiguous to the site, the high tide line, the mean high water line, soil and sediment controls, stormwater treatment practices, ownership and type of use on adjacent properties, and reference datum, National Geodetic Vertical Datum and mean sea level. Section 3 is a simple statement regarding the type of application. This is a site plan for zoning compliance. There is both Kevin Kersaden's interpretation as well as a staff report contained within the file. Part 1, site information. The application provides the information requested per the application. The project is a waterfront site. The adjacent coastal waters are the Milford Harbor. The existing site is a residentially zoned parcel and is used as a private boat facility. The parcel is approximately 5,011 square feet. The project will not disturb 1 acre of total land area. The project is not a shoreline flood and erosion control structure. Part 2A, the description of the proposed project. The proposed redevelopment is for the construction of a single-family residence. The site currently contains a building with a deck, a gazebo, a dock, a gravel driveway, and a gravel parking areas, and some lawn areas. There will be no clearing on the site. There will be minimal grading of the site, upwards of the high tide line, and no grading waterward of the high tide line. The existing gazebo and buildings are to be demolished. There will be a small increase in impervious cover. Existing impervious is approximately 17 feet. The proposed impervious cover will be approximately 17%. The existing impervious is 17%, and the proposed impervious cover will be 38%. The single-family structure is proposed where the existing house and deck area are, and a proposed lawn area. The residential nature of the use of the site will not change. The site will continue to be used as a parking lot for a boat dock, and now will include a single-family residence. The site is an existing residentially zoned lot. The proposed single-family residence will be located in the upland area of the property. The proposed single-family residence is going to be constructed with a concrete foundation and timber frame. The site will continue to be a water-dependent use for a private boating facility owned by and to be used by the applicant. The existing ramp and boat docks are to remain as they currently exist. Part 2B, description of proposed stormwater best management practices. There's currently no stormwater management system on the property. The site is quite flat. The majority of the site slopes towards Edgewater Place, away from the tidal wetlands and towards the freshwater wetlands just off-site in Edgewater Place. The proposed improvement to the parcel will include stormwater management and sedimentation and erosion control plans. The stormwater plan was developed in coordination with the Milford Engineering Department and the Connecticut DEP Land and Water Resource Development. There are statements supporting the plans from Greg Pedlewski, the city engineer, and John Goucher, environmental analyst at Connecticut DEP. The proposed stormwater management system was previously reviewed by the city engineer with the application to the Milford Inland Wetland Agency. Specific features including roof drains, which will be directed towards a hybrid bioretention infiltration trench. The proposed driveway will be resurfaced with clean broken stone. Broken stone surfaces provide the ability for stormwater infiltration and results in water quality improvements as compared to paved surfaces. An infiltration bed will be installed within the proposed broken stone parking area. The broken stone and infiltration bed, as well as the nearby freshwater wetlands, also provide effective removal of pollutants, resulting in improved water quality over the existing conditions. The runoff from larger storms will follow the current drainage patterns towards the municipal drainage structures in Edgewater Place. Part 3 is the identification of coastal resources and coastal resource policies. As previously stated, the on-site, adjacent, or off-site within the influence of the project are general resource, coastal hazard, coastal waters, developed shorefront, and tidal wetlands. Part 4, consistency with the applicable coastal resource policies and standards. This is a redevelopment project, is consistent with coastal resource policies. The project will preserve the coastal resources. There will be no adverse impacts to the general resource. The proposed single-family house will be built with no impact to coastal hazard areas. The single-family residence will be constructed following appropriate building codes as required by the City of Milford Building Department and coastal flood hazard requirements per the City of Milford zoning regulations. The main floor is elevated 4.6 feet above the base flood elevation of the FEMA flood hazard area, and there are 5 engineering flood vents provided in the enclosed area. The enclosed area will be used as a garage, storage area, and access to the main floor. There will be no adverse impacts to the developed shorefront. The existing ramp and dock are remaining. The site will continue to be a water-dependent use as a private boating facility owned by and used by the applicant. There's an existing ramp leading to the dock, and there will be no proposed activities to the existing ramp or dock. There will be no adverse impacts to the tidal wetlands. The project does not encroach into or degrade the tidal wetlands. There will be no adverse impact to the adjacent freshwater wetlands. The project does not encroach into or degrade the freshwater wetlands. There will be no adverse impacts to the adjacent coastal waters and estuary embayments. The house will be connected to the existing municipal sanitary sewer. The proposed redevelopment will not change the essential patterns of circulation, drainage, and basin configuration. The site grading is upland of the high tide line, and there is no proposed filling or grading waterward of the high tide line. Sedimentation and erosion control measures, stormwater treatment measures are included in the plans. Grading will be substantially similar to the existing grading patterns on site. Vegetation will be restored in certain areas to buffer against risks of erosion. The new structure is more flood resilient to coastal flooding than the existing structures. Part 5, identify coastal use policies. Applicable coastal use policies are general development, water-dependent use, and boating. Part 6, consistency with applicable coastal use policies and standards. This development project is consistent with the coastal use policies. The project will preserve the water-dependent use as recreational boating. The site is zoned residential. The site will continue to be used as a water-dependent use as a private boating facility owned by and used by the applicant. The land is zoned residential per the Milford zoning regulations. The existing boat ramp and boat dock are to remain. There is no proposed fill or grading waterward of the high tide line. Part 7 of the application, identify potential adverse impacts. No adverse impacts have been identified with the proposal. Comments have been provided by Attorney Green regarding degrading of visual impacts through significant alteration of the natural features and vistas and viewpoints. Connecticut General Statutes 22A-93-15F. I want to bring to the Commission the guidance the DEP provides regarding this potential impact. Within the adverse impact fact sheet on page 2 of the Coastal Management Manual, the DEP states, as an example, and I quote, example, new construction that significantly obstructs coastal views from a scenic overlook or public park. 7B, identify potential adverse impacts to water-dependent use. The Describe the features or characteristics of the proposed grading or project that qualify as water-dependent uses as defined in Connecticut General Statutes 22A 93-16. If general public access to coastal waters is provided, please identify the legal mechanisms used to ensure public access in perpetuity and describe any provisions for parking or other access to the site and proposed amenities associated with the access, e.g. boardwalks, benches, trash receptacles, interpretive signing, etc. In response, this site is historically and currently being used as an active water-dependent use as a private boating facility. The existing boat ramp and boat dock are to remain. There is no proposed public access. The scale of the project and the project location does not support meaningful public access. Public access to the adjacent coastal waters are located nearby with amenities to support public access such as parking areas, boat ramp, and restrooms. Part 8, mitigation of potential adverse impacts. There are no proposed adverse impacts identified and therefore no mitigation is proposed. Part 9, remaining adverse impacts. There are no remaining adverse impacts. Just as a side note, I want to point out that there are sections for potential adverse impacts and remaining adverse impacts, because from time to time applications are made to this commission where there are adverse impacts that can't be overcome. In closing, I want to emphasize the property is suitable for development, and in fact, the DEP through the Coastal Area Management Program has recognized this property as a developed shorefront on the coastal area map, resource map of 1979, and that additional development has occurred in this area subsequent to the publication of that designation in 1979. In the various documentation provided by Attorney Green, reiterates the Connecticut General Statutes and in part states, in quote, conduct which is reasonably likely to have the unreasonable polluting, impairing, or destroying of the public trust, air, water, or other natural resources of the state of Connecticut. In my professional opinion, it is not reasonably likely that the proposed activity will cause unreasonable polluting, impairing, or destroying of the public trust. I want to emphasize the terms reasonably likely and unreasonably polluting. These terms are used to evaluate many types of activities throughout the lands of Connecticut and specifically along Connecticut shoreline. I offer a few examples that, in my opinion, are proposed activities that are more reasonably likely to cause unreasonable polluting, impairing, or destroying the public trust. For example, sewage treatment plants, power plants, harbor facilities for storing hazardous materials such as fuel, large shoreline developments with extensive alterations to the surface and subsurface topography. Keep in mind, municipalities use the same coastal site plan criteria for evaluating these much more intensive use examples. In comparison, this proposal is a small parcel of land, approximately 5,000 square feet, which is currently developed with a building and parking and boat docking structures. The changes to the site topography are de minimis. The parcel is quite flat and as such poses little potential for sedimentation or erosion. The parcel is developed and its present condition has minimal provisions for groundwater recharge or groundwater runoff volume. The proposed activities of constructing a single-family house have low potential for causing unreasonable pollution. In regards to the public access, the parcel of land is so small that no meaningful public access can be provided. There is no parking, nor facilities, nor potential for such facilities, and literally no physical space for a meaningful public access point. Conversely, Wilcox Park and Listman Landings are both close by. These municipal parks provide parking, restroom facilities, access to water-dependent uses, and general space to provide meaningful access to the shorefront. This plan was previously presented to the Milford Inland Wetland Agency, and within the charge of the Milford Inland Wetland Agency is to review both inland wetlands, and water bodies. The Milford Inland Wetland reviewed and approved this plan, including the stormwater treatment plant and the sedimentation and erosion control plan. The plan was also submitted for review to Mr. Greg Pedluski, the city engineer, and the floodplain manager for the city of Milford, both during the Milford Inland Wetland application and with this coastal site plan application. Mr. Pedluski's reports and recommendations are part of your file. Common discussions between Mr. Pedluski and myself are focused on stormwater management, including stormwater quality. It is worth mentioning that Mr. Pedluski was part of the team to review and update the Connecticut Stormwater Quality Manual. With the process of this coastal site plan application, the plan was also sent to Mr. John Goucher of the Connecticut DEP. I've known Mr. Goucher for quite some time, perhaps 25 years. Mr. Goucher and I conversed via email and had phone conversations. Our conversation was primarily regarding stormwater treatment on this existing developed site. I respect Mr. Goucher's experience in these coastal site plans and his knowledge of the Connecticut Coastal Management Manual. Upon conclusion of our conversation, I slightly modified the stormwater treatment system to the plan currently presented and approved by Mr. Goucher. It is possible that slight modifications to the stormwater treatment could be considered. However, in my opinion, these plans meet the intent of the stormwater management and water quality. I've been part of many coastal site plan applications and have had many conversations with Mr. Goucher. On several occasions, Mr. Goucher has recommended that a particular application include public access. There was no such recommendations by Mr. Goucher with this application. In summary, regarding the stormwater management and water quality, the proposed development will have an improved effect in the water quality as well as runoff management. The plan was developed in collaboration with municipal and state governments. The site has little potential for sedimentation or erosion. The proposed activities pose little risk to wildlife habitat or tidal wetlands. It is my opinion that it is unlikely that this proposal will cause any unreasonable pollution, impairing or destroying of the public trust in the air, water, or natural resources, and that the proposal retains the water-dependent use as it now exists. I did hear a question earlier, and it's my understanding that the house at number 30 Edgewater, it is a waterfront property. It does have boat docks. It was not part of this subdivision that this parcel was originally created on. That concludes my portion of the presentation. I'll be happy to answer any additional questions, and I'll turn it over to John to walk through the site plan.
Thank you for your very thorough presentation.
Thank you. Thanks, Ron. John Wicko, architect for the project with offices at 58 Prospect Street. Talk about the building, and how it fits on the site. As said before, it's in the R12.5 zone, single-family house of about 2,400 square feet on the 5,010 square foot lot. The existing structures, which are located at this same location of the house and towards the harbor, are going to be removed. There's a deck, a gazebo, and a third building that'll be removed. Portions of the site that are to remain are wooden retaining wall, the gravel drive and gravel access, and a wood fence towards the south and north portions of the site. The footprint of, the building's footprint meets all the setbacks and all the zoning requirements for this zone. Everything is outside of the 25-foot setback from the high water mark. And we are using the projections from the yards for meter platform, balcony, and mechanical racks that are attached to the house. The building area and lot coverage are under the required limits for the site. Those are the site impacts that the residents have, which are no impacts, they all comply. Moving on past the engineering, we have our foundation plan, which is solid concrete with a natural stone veneer, meeting the material requirements for the FEMA Act. We have flood vents that are within the solid stone and concrete, which meet the requirements of the flood flow through the structure. The project is in, excuse me? The project is in the, has a base flood elevation of 11 and a design flow elevation of 13, which all of our utilities and structural members are above. Going through the house, which is a typical single-family residence, just calling out some of what would be the normal activities within the single family. We have an elevator that goes up to the first and second floors, stair access for ingress and egress, kitchen, living, laundry, dining, decks, balconies, bedrooms at the second floor, 2 bathrooms, closets. The finished attic has an office area, observation deck, and all within the roof, including some mechanical spaces up in that area. The elevations, the height of the structure is raised again to meet the flood requirements. The average height is 34 feet 7 inches, meeting your 35-foot requirement. We have dormers which are under the maximum allowed that could be over 35 feet, all within the main roof planes. Siding, traditional residential coastal shingles, natural stone, which we talked about, and asphalt roofing shingles. I appreciate your attention. That concludes my architectural presentation.
Thank you.
You're welcome.
David, if you would please just weigh in on, because there's various roof lines, how do we, where do we measure for the different roof lines?
It's to the midpoint of the highest main roof. So, right there.
So is it that shed dormer to the right as we're looking at it now?
It's, if we were to flip the, well, they've got this measurement here, hold on. It is, I believe, to the midpoint of this roof here.
Yeah, the main roof, David.
The main roof, yeah.
Okay, do we have another elevation to see the size of that shed dormer?
A3? 1A3?
A3.
Okay, so it looks like that shed dormer is only the width of those 2 sliders or whatever they are?
Yep.
Mr. Sulkus, if I could point out, on 1A4, there's a worksheet diagram that clearly describes the dormers and the areas and its relationship to the floors below, with the percentage being 18.4%, which is well below the 35% dormer allowance.
Thank you for the clarification. Mr. Hirsch.
Mr. Wicko, good evening. How many square feet is this house?
2,400.
How wide is it and how long is it?
Let's see. The width is 29 feet, 4 inches. And the length of it is 39 feet, 6 inches for the main house, and then the deck is another 3'8".
Thank you.
You're welcome.
Are there any questions from the board at this point? No? David, would you let us know what you think?
The applicant is proposing to construct a single-family dwelling of 34 and 7 1/8 inch in height. The lot is, in its current configuration, has been recognized by the assessor's office and taxed as a single lot since at least 1980. More recently, in a 2008 survey that was submitted on the land record showing the single lot in its current configuration. No adverse impact to coastal resources is anticipated. An as-built drawing confirming the proposed building height will be required prior to the issuance of a certificate of zoning compliance. The Connecticut Department of Environmental Protection, DEEP, has reviewed the application and recommends that newly placed fill for drainage located at each of the downspouts and in the parking area be tested after compaction to confirm that their hydraulic conductivity meets the recommendations of the 2004 Connecticut Stormwater Quality Manual of between 0.3 and 5 inches per hour. This condition would be noted on the drawings reviewed for the zoning permit. The application is substantially compliant with the Milford zoning regulations.
Thank you. Is there any questions or comments from the board before we open the public hearing? Yes, Eton.
Good evening, Mr. Attorney Kersadian. How are you? Are there any easements on this property?
No, not that I'm aware of. I looked at the deed today. I didn't see any in the title.
And have members of the public, to your knowledge, used that gazebo?
No, it's a private property.
Thank you.
There's no facilities in it or anything like that. No. I do, for clarification, there's no easement. I did receive a, I don't know if it was on Friday, I think, from Attorney Green's office, Attorney Lasky, who's here tonight, various materials, some of them overhead photos, kind of duplicative of some of them overhead photos we provided, but also an old reference to a deed restriction for the old Lot 49. But deed restrictions, so I just want to be clear, easements are different than deed restrictions, and deed restrictions are respectfully not the purview of the Planning and Zoning Board. You don't interpret whether something's a legal deed restriction or not. There is and I've had that conversation on past applications and confirmed that with the city attorney's office, but also deed restrictions have to be, there has to be somebody that has the right to enforce it. This was a very old reference to a deed restriction on that 10-foot wide lot. But I also compared that deed restriction, even if it did make a difference, which it doesn't, to the site plan, and we have a 10-foot setback anyway. So that Lot 49 is, if you're looking on Edgewater Place towards the water, is the very far right lot of this project. So there's no we're not in that deed restricted area anyway. But I don't, that's an old deed restriction between two previous owners, and I don't think that has any validity anyway. But if that's, I just wanted to clarify that.
Any further questions before we open the public hearing? Okay, this is
I have a quick question.
Yep, go ahead.
Attorney Chrysaden, about that deed restriction, because I had a question on it. It says that I think it's lot 49. Said promises shall be subject to the following restrictions. All the lots shown and designated on map in section B shall be used for the purposes of building a dock or a private boathouse not to exceed 12 feet in height above present level of the land at such place, and said lot or lots shall be used for no other purpose. I mean, I don't understand what is a deed restriction for if you're saying that it doesn't come into effect.
It doesn't come into effect when you talk about the zoning regulations and what's allowed by the zoning regulations or by the CAM Act. And that original, I think there's two different deed restrictions. There's that comment, which is, I did read that. That's in addition to the 10-foot referencing lot 49. It references all the lots in the subdivision. But it's not limiting the use of the lots, number one, to just boat docks. That's not how I read that language. It says, I mean, I don't.
And that's how I read it.
Yeah, but it's not. That's not
because that's what it says.
It's being deeded for those purposes, but it's not a private deed restriction that somebody can enforce. First of all, secondly, over time, as the zoning regulations change, and I think single family was allowed when the zoning regulations were established. In this was Residence A zone. It was single family lots from the very beginning. So it could have always been used. The only person that would have had the ability to enforce an original deed restriction from a subdivision map would have been that original developer, number one. Number two, the case law is very clear that the Planning and Zoning Board doesn't consider, they don't weigh in on whether private deed restrictions are either valid, enforceable, who has the rights to enforce those. So legally, there's no deed restriction on this property. Title, you could go back and title on a lot of these different properties, and there's things over the years that would either have fallen off title or no longer be enforceable because the parties that originally had the right to enforce it can't enforce it any further. So, and I know that people don't like being told that you don't have the jurisdiction to decide whether a deed restriction is valid or not. I don't like saying it that way, but that's what the case law says. And I had a similar case. I think it was also a waterfront property a year or two ago that I did the research for, and it was in front of, I think, the ZBA. And we had a similar conversation, and the city attorney's office did agree that zoning boards, whether it's ZBA or P&Z or what have you, don't determine deed restrictions.
Thank you.
Any further questions at this point? I would just like to take a 2-minute recess. I need a drink of water, and we'll be right back. Them 5 minutes up front, and then if we don't go too late, they'll be welcome back to complete the things that they would like to share. So at one point, if you would just state your name, excuse me, and address for the record, you would have the floor.
There we go. Good evening, Chairman Quish and members of the board. My name is Linda Lasky. I practice law in Bridgeport with the law offices of Green and Gross at 1087 Broad Street in Bridgeport. Just as a preliminary matter, I do have a few items to pass out. One is a set of documents that we had submitted on Friday, but I'm not sure whether they actually were uploaded. And if it's all right.
Yeah, I mean, you don't need to get them to it now because we're not going to read them now. So you can give them to us later or leave them there and we can pick them up however you want to do it.
Okay, I'll do that. So another sort of point of order issue. I know that Attorney Green from my office appeared before you at the initial, not public hearing, but meeting when this application was first presented. And at that time, my client, I'm here representing Christopher McKenna, I apologize, of Rose Street. He owns property that's adjacent and across the street from the subject property. And he spoke at the last meeting. I'm wondering whether that testimony can be incorporated by reference into this public hearing.
Yes, it can.
Okay, thank you. I would like to present Mr. McKenna to allow him to make some comments initially.
Go ahead. And again, remember that we're kind of segmenting the time, so 5 minutes between the two of you, and then we'll let the public come in. Thanks.
Good evening, gentlemen, Commissioner Quish, and the members of the board. My name is Christopher McKenna, and I live at 24 Rose Street in Milford, Connecticut. I'm here tonight in opposition of the Coastal Area Management Site application before you, and I wanted to start the discussion with the original maps of Walker Manor, dated and filed with the town clerk on June 10th, 1924. I've dropped off a packet to all of you folks up there. It includes 5 different deeds with some deed restrictions. They're not necessarily these deeds, but they're just deeds that are along the harbor, and it really is there just to show intent that these originally were out there for just for boat slips. I also included similar, the maps that are up there, I just gave you copies for yourself. And I also, in that packet, have the definition of what a building lot is back in 1930. And I also left up there the regulations for 1930. As you can see on this map, it shows 79 lots between Harbor Avenue and Dock Road. The upper section of the property runs along Gulf Street at the top of the upland and down to Edgewater Place, which is a paper road at the bottom of the upland. The 79 lots are included in the upland portion of the map described as upland lots. Also, please note 3 structures included in the upland portion of the map. The 3 structures are on the original deed or on the original map, and they are included, they include a home between lots 21 and 22, and a second home and a barn on lot 26, and those are all in the upland. The upland area includes 4 streets running from Gulf Street to Edgewater Place. 1 street runs parallel to Gulf Street, and that's Walker Avenue. It runs from the backside of Carrington to the edge of Adams Street, which is also the start of Edgewater Place, the paper road. The paper road, known as Edgewater Place, runs with a bend from the end of Adams, or the end of Adams and the end of Walker Street along the harbor all the way over to Wilbur Ave. The total square footage of the upland lots is approximately 900,000 square feet, or 92% of the parcels on the map. The property along the harbor includes 79 10-foot wide strips of land by approximately 100 feet long, and they sit in the salt marsh between the harbor and Edgewater Place. The total square footage of the 79 10-foot strips in the salt marsh is approximately 79,000 square feet, or 8% of the parcels on the map. The 79 parcels in the salt marsh are defined as B lots on their deeds, and each B lot has a lot number between the numbers of 1 and 79 that correspond to the upland lots. The original intent of the 10-foot wide strips was harbor access for each of the upland buildings. Now I want to get into the Milford zoning regulations. The original zoning regulations were approved on June 11, 1930. The definition of the term lot included in the original regulation, Section 1, Paragraph C, page 9, reads as follows. A lot is a parcel of land occupied or designed to be occupied by one building and an accessory building or use customary incident to it, including such open space as arranged and designed to be used in connection with such building. The important critical phrase here is designed to be occupied by one building. A 10-foot wide strip, as displayed on the map of Walker Manor dated June 10, 1924, was never designed to be occupied by a building. If the owner-developer wanted to make the B lots located in the Salt Marsh building lots, he would have designed them to be building lots like the rest of the lots in the upland. Instead, he made these 10 by 100, clearly not designed for a building. Again, the original intent of the B lots was to provide access to the harbor and the water enjoyment. Please review the map dated June 10, 1924. Use your common sense when evaluating the map and the B lots. Do not get overwhelmed by all the paperwork filed by the applicant's attorney. The information is designed to confuse and to muddy the waters. The reference to the court cases included in the package do not apply to these B lots. These lots do not have homes on them. They never had homes, and they never were intended to be building lots. Since 1924, these slips have been used for harbor access. When the map was developed, the intent of the B lot was harbor access. The lots were in the salt marsh, covered with water every day as the tides came in and out. Not until the owners of the B lots developed the lots and built bulkheads along the harbor did the water stop filling the salt marsh. The development of the boat docks over time destroyed the salt marsh. The lots are not legal non-conforming lots, and the applicant has not given us evidence to prove that they are. If you want to build a lot on Edgewater, the district requires the zone to be a 12-5 zone. A couple things along the legal non-conforming lots. What's happening here is the Planning and Zoning Department is not following their own regulations. The attorney and the people in the building department aren't allowed to just come up with their own rules. We have regulations in place, and if they're to follow the regulations on 6.1.4, it calls for a certificate of zoning compliance. And it says a certificate of zoning compliance has been issued by the zoning officer stating that such lots, structures, or use is an existing legal non-conforming use, structure, or lot, and or that such construction, blah, 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 meets these regulations. So they're deciding that it's a legal non-conforming lot without doing any of their homework. They have not went back to 1930 to determine who owned the lots. If the lots were sold off and the conformity went from, if you had 5 or 4 lots, these 10-foot slips, and you sold them off, then they become not legal non-conforming lots anymore. They just become non-conforming lots. So I don't think that they get to decide what is legal non-conforming. I think there's got to be, some paperwork, and it's required right here in the regulations, and it's not in the file. So I think for tonight, I would like you to, again, I don't think these are legal non-conforming lots, and I would like you to vote no on this CAM application because these are not legal lots. Thank you.
Thank you.
All right, I will do my best to be quick. I had a much more extensive presentation ready, not realizing we were going to be limited to 5 minutes. But just as a matter of bullet points.
You are at 9 now, so we're giving you a little bit of leeway, but
Thank you.
please
Much appreciated.
understand we are going to let the public speak, and then you're welcome to come back. I don't want to truncate what you're trying to say, but fairly shortly we're going to let the public speak.
Thank you. So why don't I do a bullet points, and then with the understanding that you'll allow me to come back. And
I will.
I promise I won't be too long after that. I just have some legal issues that take you back to law school, because these are important. But just as bullet points, This CAM application should be denied because it fails to satisfy all required CAM standards, one of which, as we've heard, and the applicant concedes, is that the application must be fully zoning compliant. In addition, it also has adverse impacts on coastal resources, including the views of coastal resources, which are significant, and they will be substantially impacted here. The lot is concededly not conforming. It doesn't comply with lot area, lot width, and depth. The basis for the applicant's claim of a right to use this is that it's a non-conforming subdivision lot, I've heard, a non-conforming lot, but we have heard no evidence that this is a legally existing subdivision lot. It certainly is not a subdivision. That's a term of art that refers to lots that are created in a subdivision approved by a planning commission after the adoption of subdivision regulations. These lots, this Walker Manor map was filed in 1924. Subdivision regulations weren't adopted in Milford until 1929, and zoning regulations in 1930. Therefore, while there is a statute that protects subdivision lots that were approved by a planning commission, that is not the case here. These are pre-existing parcels and not lots. And that's something that I would like to address later on, is that the zoning regulations now and in 1930 distinguished between parcels and lots. Lots were designed for buildings, as Mr. McKenna has mentioned. Parcels are not, and there's no clear right to automatically be able to use them for a building. I'll also be handing out an appellate court decision called Johnson versus Board of Zoning Appeals of the Town of Stratford, and that's at 35 Connecticut Appellate 820. It's a 1994 case that is pretty squarely on point with this, where the Connecticut appellate court found that a pre-existing lot that was vacant and not actually used for a house is not grandfathered in. There's no non-conforming existing residential use that can be continued. And I'll talk about that as well later. One additional thing is, even if this were considered a legal lot, the existing use is for boating purposes. If now the applicant is going to change the use for a combined boating and residential use, then a variance would be required, even if it were considered to be a legal lot. A variance would be required because this is a non-conforming, undersized, not legally existing, but undersized lot, and we're going to be adding a second use to the property. And under your regulations, a new boating use would require a special permit. Here, we're going to have a combined residence and boating use, which would require either a variance or a special permit, or perhaps even both. I'm not sure how that works. But I suppose that's the bullets. Oh, one more issue is and I understand that you're not concerned with private property rights specifically, but just something to be aware of and consider is that, especially in plot plans that were recorded prior to the adoption of zoning regulations, it's often found that there are implied covenants and restrictions based on the design and layout of the lots. And in this case, we would argue that all lot owners of homes in the development and of the dock parcels would have a right to enforce the implied restriction that is apparent from the design to keep the waterfront lots as strictly for boat lots and waterfront access and not for houses, because they clearly weren't designed for that use.
Thank you for your, trying to move that along. So if there are members of the public who would like to speak, if you could go up to that side over here. I think that microphone works, David, is that correct?
Could I just add one more thing? You guys had mentioned the property at the end of Edgewater.
Yeah, actually, we're going to wait.
Okay,
yeah,
sure.
We'll let the public speak. Yeah. If you would just please state your name and address for the board, and if you would try to keep your comments to about 3 minutes.
My name is Joseph Newman, and I live at 23 Wilbar Avenue near the parcels that are in dispute. The question that I would start with is, has anybody seen Jurassic Park, the dinosaur movie? The critical question in that film is not whether or not they could, but whether they should. As Mr. McKenna has pointed out, these parcels were never intended for single-family homes. If you look at the design that Mr. Wicko has presented and you walk through our neighborhood, it is so powerfully out of scale with what is there that if this project were to go forward, years from now, people would walk down Edgewater Place, which I believe is a municipal public road, not a private road, as somebody has marked, in case you've been down there. And they would look at that house and the house that got rushed up last year, and they would say, who thought this was a good idea? What does Milford stand for? Why are we trying to do this to our community? We are an accessible coastal town. We are a walkable town. We are an open town. Projects like this fundamentally change the character of where we live. I'm not a lawyer. I am not here to debate whether or not it's legally permissible. I am not here to debate whether or not they've ticked all the right boxes. But I am here to tell you that this is a bad idea. Because if you were there and if you saw this project go up, you would say to yourself, I can't believe this happened on my watch. Further, regarding the public impact, I do not know the details of a coastal management application, but I can tell you that both from Wilbar Avenue and from Harborview and from Scoopy-Doo's and from the gazebo by Milford Boat Works and from the kayak boat launch, you can see this property. And if this house were to be built, that view would affect every single person in town who visits those areas. It is a public view. It is a public issue. Furthermore, if you go down there, especially now, all of the recent storms flood that area well over Edgewater Place. So I'm not sure about runoff. I'm not sure about quality of settlement. I'm sure you've done your homework. But the fact of the matter is, when a storm comes at high tide, you can't drive there. You can't get in and you can't get out. And that is a serious issue for taxpayers, because if something happens down there, Milford is already encumbered by neighborhoods that flood and emergency vehicles have to access. Why in God's name would we add another when we don't have to? And that is all I have to say. Thank you very much.
Thank you. If anyone would like to come up and speak, please come up and take the seat. Again, if you would, state your name and address for the board, for the record. Thank you.
My name is Regina Sirico. I live on 61 Wilbar Avenue. I've been a resident since 1983. That's 40-some-odd years. I've seen a lot of what happens along Edgewater Place. In the past year, we've had 3 rainstorms, not hurricanes, not anything significant, and the water level rises up Wilbar Avenue past where the fire hydrant is. It's got to be at least 300 feet from the harbor. The stormwater drains that currently exist there, the water comes up the stormwater drains, not down. There are significant issues there. Why we would even consider putting homes down there, I just think it's a bad idea. Thank you for your time.
Thank you. Anyone else, excuse me, anyone else like to speak? Just come on up. You don't have to wait for me to ask. If anybody else is willing to speak next, just pop up when the next person is done. Thank you.
Sir. My name is Amy Conowitz. I live at 73 Wilbar Avenue. I'm actually the last house on Wilbar Avenue, so I'm at the corner of Wilbar and Edgewater as you approach the marina. The fire hydrant that Reggie referred to is in front of my house. Luckily, my house is on an upgrade of about 8 feet, so the water doesn't generally reach. It has reached my driveway, which is several hundred feet from the water. There's a couple of things I wanted to point out. I've lived there since 2001. I know the applicant's attorney mentioned 2004 and the gazebo being built and so forth. What wasn't mentioned is that he did not apply for a gazebo. He applied for a residence at that point in time and was denied. So I didn't hear anything about what would have changed in the zoning regulations so that he was denied at that point. He was not allowed to build any structure that had solid walls. So what he built was the gazebo, and for quite a few years now has plastic tarping that comes down the sides that he ties to create, solid so that things don't blow around during the storms. And I can look out my window. My dog looks out the window all the time. When there's a lot of rain, like Reggie said, the water comes up through the drains. It doesn't just come up through the drains. I've taken pictures and posted them to my friends. It's part of the river. There's a current. I have pictures of it on my phone. It literally turns into a current that goes all the way up Edgewater Place and about 10 feet into the properties that are actually Rose Street addresses. I also in lieu of that too, I wanted to mention I was really surprised by the picture and the fact that there's an elevator going to the first and second floor that must start at the ground level and that there's a garage on that level, because that will flood. We get several feet of water. The storm that we had in, I think, January, I'm not sure, beginning of February, there was several feet of water in that location. So those cars would have to be moved. I'm not sure how anything mechanical can really go down to that level, because it will absolutely flood. And there's so much water that I can't even walk my dog down Edgewater Place for a few days until after it all drains out. So that does become a very muddy area. So I think that's all really I just wanted to point out, in addition to just clarify some of the things and add to them, to what she said. Thank you.
Thank you. If no one else wants to speak, we'll go back to here we go.
My name is Linda Gwozdik. I live at 41 Rose Street. I've been there since 1962, so I've been there a while. That property has always been boat-related, just a landing for the docks and for strictly boats. No one ever even thought of building anything there until we had this recent one that the lawyer referred to, which came up overnight, and it's up on pilings, I don't know, 20 feet in the air. That one came up with no one even knew that one was being built. At least this one, they are doing it and letting us know that it's going to be built. But it's strictly inappropriate for the neighborhood. And as someone said, this last rainstorm, you couldn't even see where the harbor began and the land ended. It was total flooding. I have pictures on my phone. I wish I had printed them out. I would have submitted them to the meeting tonight. Thank you. Please vote against this. Thank you.
Thank you.
Hello, my name is Allison McKenna. I live at 24 Rose Street. I just wanted to come up here and say that I am in opposition of the coastal area management application, and I've lived at 24 Rose Street for 15 years. I often walk my dog on Edgewater Place, and I have seen the flooding. I agree with what everyone else has said, and I think that you guys should oppose this today.
Thank you. All right, if you would like to take the microphone and again, it is really hoping that you'll make it as brief as possible. Yeah, go ahead.
I'm going to go real quick. I wanted to go over the properties. Somebody had a question about the property at the very end. Well, those properties are lots 1 through 10 on the map, or 1 through 12, and that lot is made up of 16,745 square feet, And it's got a house on it, and it has a dock on it, and it was part of the original map. I believe when they tried to do this lot originally, I think they were trying to put 3 houses on there, and the Milford Planning and Zoning shot it down, and he was able to get 1, because I don't believe he met the 12,500 square foot zone. In contrast, that piece of property to the current one that we're talking about today, that's about 11% or 5,000 square feet, but it's about 11% of an acre, and it's literally 5,000. And the house that they built next to them, which we are currently in court over, that property has about 9% or 4,000 square feet. So, thank you. And
Thanks.
also, we have pictures we could drop off of all the flooding if you guys want to cruise through those. So.
All right, so now for some law school, and I apologize. Just as a basic matter, what is a legal nonconformity? A legal nonconformity is a legally existing nonconforming use or structure that was legal and actually existing when the zoning regulations were adopted that caused the use or structure to not conform to the zoning regulations. And Section 8-2 of the general statutes, which is part of the zoning enabling legislation, which I'm sure you are very familiar with, requires that zoning regulations cannot prohibit the continuance of any non-conforming use, building, or structure existing at the time of the adoption of the zoning regulations. So the focus in 8-2 is on allowing continuance of non-conforming uses, buildings, or structures. There is no provision specifically for lots per se. 8-2 only addresses uses and buildings and structures. So again, that is another, the commission, a zoning commission, zoning board in this case, doesn't have any authority to, other than what is granted through the enabling legislation. So if, in this case, the Milford zoning regulations were deemed to allegedly permit continuance of a nonconformity and that would be in contravention to 8-2, that would be an unlawful ultra vires statute. So, all right, in this case, we have no evidence that the subject property was designed for or ever actually used as a lot for dwelling use. I would like to just cite a case, Helicopter Associates, which is a Connecticut Supreme Court case in which the court held that for there to be an existing use that's legally nonconforming, the premises must be so utilized as to be known in the neighborhood as employed for a given purpose. Such utilization combines 2 factors. 1 is the adaptability of the land for the purpose, and 2, the employment of it within that purpose. So in this case, these parcels were never actually utilized or known as being designed for use as building lots, and they were never employed within that purpose. We know that these were vacant lots as of 1930, and again, if I will submit the photos, if they haven't been uploaded, that were submitted on Friday, but we have aerial photos beginning in the 1930s and progressing every several years that show the development of these lots and adjacent parcels only for boating purposes for many, many years. And I'll just note that the deed restriction that was submitted was not submitted for the purpose of showing that, you know, there may or may not still be a deed restriction in existence, but it was to show that Lot 49 was actually used for boating purposes, as were 44 through 48. These were only used for boating and accessory structures and uses throughout the years, and never ever for a house lot. As I mentioned before, the Walker Manor map is not a subdivision that would be protected under Section 8-26A. So the mere fact that parcels are shown on that map doesn't create non-conforming rights. And again, this Johnson versus Zoning Board of Appeals case is directly on point. And in that case, the court held, quote, merely recording a map of land prior to the advent of zoning regulations does not automatically exempt a non-conforming lot from subsequent regulations. Where land is irrevocably committed to a particular use, however, Section 8-2 will protect that use from the subsequent enactment of zoning laws. Because undeveloped land has not been irrevocably committed to any particular use, Section 8-2 does not protect non-conforming undeveloped lots. The court further held that although the zoning regulations that were at issue in that case, the Stratford regulations, actually included in the definition of lot parcels of land that had not yet been developed, even so, the regulations provided for those parcels to be, they called them lots. The court held that the undeveloped property, in order to be legally existing non-conforming, had to have been used for the proposed purpose for a house lot in order to be protected as a non-conforming use.
Well, thank you. Now, we do need to let the applicant rebut, and we do need to give you another chance to rebut the rebuttal. So if, obviously, we're going to be given the case law, so rather than have you sort of read it to us, we're going to be reading it at one point. So if that was really the gist of what you wanted to continue to do, I would ask that you refrain and let us move forward.
If you'll just give me a moment to scan here. I did want to talk about the zoning regulations in particular.
We'll give you another couple minutes and then please.
Okay. So in the 1930 regulations, the 1940 regulations, as Mr. McKenna did discuss, lot is defined as a parcel of land occupied or designed to be used for one building and accessory buildings or uses customarily incident to it. And in contrast, the word non-conforming in those sets of regs only applied to buildings and uses and not to lots. The current regs distinguish between parcels and lots. That's done in the definitions in Article 11. Also, Section 6.1.1 of the regs defines a non-conforming lot as one which existed lawfully on the effective date of the regulations. So again, it refers to a non-conforming lot, while the regs also have a definition of parcel, which is distinct. So where non-conforming is used in the regs, it's used with respect to lots and not with respect to parcels that aren't legally existing lots designed for buildings. Section 6.4.1 also provides that a non-conforming lot may be used if the lot was of legal size when it was created as a lot. And note there that it had to be created as a lot. Again, a lot and not a parcel, a lot for use for buildings. I would just note Section 6.1.2 similarly distinguishes non-conforming use, structure, or lot that may be continued. Again, continuation is a key component of non-conforming rights. And Attorney Kerseiden had raised the issue of the uniformity rule in a different context, but I would submit that the concept of allowing just, a compilation of small undersized parcels to be treated as a lot and not requiring it to satisfy all the lot area standards and other standards for, would be giving special treatment to certain property owners compared to others, and this would violate the uniformity rule that's inherent in Section 8-2, which requires that zoning regulations treat all lots and all land in a zone the same. So all zoning regulations shall be uniform for each class or kind of building, structures, or use of land throughout each zoning district. So in this case, to allow an undersized lot that was never used before as a lot that existed prior to subdivision regulations would be to give an unfair advantage and sort of a windfall, if you will, to this property owner compared to other owners of land in Milford. I covered the special permit issue with the two uses, and I would just note, just in response specifically to Attorney Kersaden's comments and his consultant's comments, that Mr. Sulkus it was quoted as not stating that this application was zoning compliant, but that it was substantially compliant. Not fully compliant, substantially compliant, and that's simply not enough for a site plan. A site plan has to be compliant with all required standards. There's no, almost, it's 100% or it's a no. The fact that the harbor is a developed area doesn't mean that we should allow creation of new non-conforming lots and structures on undersized parcels directly on the waterfront, which is a precious and valuable resource, an environmental resource, something that's enjoyed by the public. The fact that there's an address to this property is not relevant at all. It just reflects that this property is being used for a non-conforming dock use, and there's electricity there, and there's really no relevance to the fact that there's a street address. I believe it was Attorney Kersaden who said, well, they could have combined lots back then and built a house on them, but for whatever reason, that wasn't done. And that's actually exactly the point that we're making here. It wasn't done. If there were houses on the waterfront on, combined lots back then, before 1929 and 1930, then we would acknowledge a right to continue the use of those house lots, but it wasn't done. It simply wasn't done. And unless there are any questions for either of us,
Any questions at this point? Yes, George.
Attorney Lasky, good evening. So you read from a case, John.
Oh, excuse me. Under what procedure do we ask the public, and that's what they are, the public, questions?
Chairman Quish allowed me the opportunity to ask questions.
Well, I think that, I think that Brian's right. I think that I misspoke, and they don't have standing to answer questions. You can ask David a question, and when the applicant comes back, you can ask the applicant a question, but we don't really have a purview for interaction with the member of the public. We did give quite a bit of leeway to these members. And
you did. You gave them a lot of rope.
Yeah, and so you can ask David the question or and see if the answer pops itself out. But
the reason why I bring it up is because it's clear that Attorney Lasky was trying to create a record.
So, listen, I'm not going to put up with this. We're not here to be the jury and let these two lawyers fight this out today. These folks here are not, this isn't a courtroom. They're just public, just like those folks. We don't get to ask them questions. We don't get to ask them questions. Just because he brought a lawyer here, we're going to change the rules?
Good point.
We got to follow the rules, guys.
Good point. Let's move forward, and the applicant has the floor for rebuttal.
I agree we should follow the rules, and we probably should start at the planning and zoning
I'm sorry,
department.
sir. You don't have any further standing.
Good evening. Again, for the record, Kevin Kersaden, 3 Lafayette Street. Just real quickly, I wanted to touch base back with Mr. Zaharides had referenced that deed. I took another look at that because I did look at that today, and just real quickly, this deed applies to lots 49 and 50. So this other language in here about all the lots that are designated in Section B shall be used for that purpose, there's even a further reason why it doesn't apply to all of these lots, is because this deed is only for lots 49 and 50. It's not for all of the other lots. I'll try to be brief and as a result probably be a little bit blunt about it. There's no engineer here from the opposite side to tell us that our engineer is incorrect or that there's some adverse, there's no professional opinion that there's an adverse impact to the coastal resources. The fact that there's flooding in the area, we're all well aware of it. It flooded all the way out to Oldfield Lane. And if we didn't approve houses based on flooding, there'd be, you wouldn't have approved 69 Melba Street earlier tonight. These types of properties exist. They're old lots or combination of lots. Probably a lot of them on the shorefront, a lot of them in the flood zone. What's important as far as the zoning regulations is that we meet the flood part of the zoning regulations, which this application does because it's elevated in a flood zone. So that's the important part. I just looked up Johnson v. ZBA Stratford. The case did sound familiar to me. Respectfully, that's, I think, references Connecticut General Statute 8-26A. That doesn't apply here because 8-26A is when a Planning and Zoning Commission approves a subdivision map, and then those lots have certain rights until they're developed, that they don't have to comply with the change in zoning regulations. That is not at all on point here. This subdivision map, it was a map of record, as the Department of Permitting and Land Use would call it, was not approved by the Planning and Zoning Commission. So in that case, 8-26A doesn't apply one way or the other, in favor or not in favor. And I've been doing this a long time in Milford, and with a lot of these lots, and I've gotten a lot of lots certified before, under the old version of 6.4.2. Historically, the way that Milford treats the zoning, uses the zoning regulations and applies them to these old lots. This is important because you have property owners that need to know with certainty what they can do with their properties when they purchase the property. So historically, if you had a lot that was, a 5,000 square foot lot that had never been developed, and it's in an R75 zone, for example, if you could show that, and this lot, whether it's on a subdivision map that was approved by a Planning and Zoning Commission or a subdivision map that was filed prior to the existence of the zoning regulations and the subdivision regulations, the standard has always been in Milford that if you can show that it is, you can comply with all the zoning regulations, setback regulations, coverage regulations, all of those things, here is your zoning permit for that house. And so in this particular case, this house and this proposal complies with all of the bulk regulations. It complies with the lot size because it's a pre-existing legal non-conforming lot. Milford even has other sections in the, under Section 6 of the non-conforming, where it says, notwithstanding all of the other requirements we have, you can consolidate lots. And then there's a certain procedure under 2.3.1 of the subdivision regulations. I asked David at the beginning of this process, should I follow that procedure? And all that does is you post a sign for a couple of weeks or 10 days. And, this is, the zoning officer has determined this is a legal building lot. Appeal to the Zoning Board of Appeals if you don't agree with that. And based on the facts and the history of this lot, it was determined it wasn't necessary because your own 6.4.2, before you had the moratorium, had already merged this, and there was already a building structure on this lot. A building permit, if you look in the exhibits to, I think it's the documents that I filed on February 20th, there's a building permit issued for this gazebo structure, and there's other permits issued. It does make a difference because they don't issue permits for those types of things if it's not considered a legal lot. And once it's a legal lot, you can use that lot for what's allowed in the zone. If you were gonna say, oh well, it had always been built boat docks, and then the zoning regulation changed, and you could do something else. Under that theory, you would never be able to do anything else with your lot as the zoning regulations changed. So that's why that's not legally correct. It's only used for boating for a certain number of years, or once again, that's the same point. You're allowed to change the use that's something that's allowed in the zone, which is very important to property owners. There needs to be certainty in what you can do with your lot. And if Milford treats pre-existing non-conforming lots a certain way for 40, 50, or 60 years, and then they decide because, there's opposition to one particular application, where usually these CAM applications are 5 or 10 minute applications, and most of them are approved or they're approved with conditions. You can't upend the zoning regulations because of public comment. We've more than complied or shown that this is a legal building lot. Mr. Solkis agrees it's a legal building lot. The zoning enforcement officer agrees it's a legal building lot. This is a developed lot. If you also look at those exhibits, this lot has 3 or 4 different structures on it. It's got the docks, which are a legal use as of right in a residential zone. But if we were going to apply for docks today, it would be a special permit. If we apply for a house in a residential zone, it's just a site plan application. So by having a single family house on a single family lot instead of a gazebo, you're actually making the property more zoning conforming than what it is right now. That's just the reality of how the land use works. So I don't have any other further comments at this point in time. I'm available for questions.
Thank you. Go ahead.
Mr. Crusaden, you
Yes.
just mentioned that the zoning enforcement officer has confirmed that this is a legal building lot.
The zoning enforcement officer said that the project is zoning compliant.
Okay. No, you just said that he said it's a legal building lot. That's what you said. So 6.1.4 says that, it says certificate of zoning compliance.
Yes.
That says no non-conforming lot shall be built upon unless a certificate of zoning compliance has been issued by the zoning enforcement officer stating that such a use, structure, or lot is an existing legal non-conforming use, structure, lot, and that such construction and reconstruction is in compliance with the applicable provisions in these regulations.
Right.
Is there a certificate of zoning compliance on this lot?
So the certificate of zoning compliance is issued prior to the certificate of occupancy, and there's case law.
Actually, this says
I understand.
This says prior to being constructed. That's what our regulation says.
Mr. Chair.
So go ahead, sorry.
No, you finish.
I'm just reading what our regulations.
No, that's fine, but you're welcome to continue.
I'm just trying to get clarification on that.
If you have more to say,
I'm sorry?
You have the floor if you have more to say.
I think I said what I was saying.
Yeah.
So a couple of things. We have a conforming use on this lot. We gave permits for the structures that are there. We did that, giving those permits on those 4 old, because I'm going to call them old because they're the original lots, they're zoning compliant. This particular section of the regulations wouldn't apply to this since we've issued permits on this, and this lot has been recognized as being a single lot. And the logic behind that of why this doesn't apply here is We have thousands of lots. Probably half the lots in the city fall under that designation, especially along the shoreline. According to this, every lot that is undersized, does not comply with zoning in terms of setbacks. Anytime they come in for a zoning permit, we would have to issue a certificate of zoning compliance to say that the house or the use or the lot that's already there is okay. And we don't do that.
Yeah, okay. We have, the applicant has yielded the floor, so you have a chance to.
Yeah, I just wanted to follow up. Judge Frechette, in here in the Superior Court of Milford, has interpreted that regulation in a previous case to mean that the certificate of zoning compliance, if required, needs to be issued before the certificate of occupancy, which is typically the standard course. But you did bring up a good point, Mr. Zaharides. The letter by Stephen Harris, the zoning compliance review, which they call it, the ZCR or whatever, that functions, in my opinion, as the certificate of zoning compliance. So if the zoning officer says that the project is compliant, and I have to tell you, I have butted heads on the opposite ends of this with David and Stephen for years now, and they're very difficult and they're very thorough in their jobs. So if they say it's zoning compliant, then everything's been thoroughly vetted. Thank you.
Mr. Chair, just one more point. And you saw a very good example of it this evening. I use the word substantially zoning compliant in reports to give myself wiggle room when there's something that I might miss, such as in 277 West Avenue, which we had earlier this evening, which I thought was substantially zoning compliant, and then realized, oh no, they didn't provide us with the underground electrical. So as far as I'm concerned, this is zoning compliant.
And then, obviously, that's why we're here, because there's different opinions on that. The applicant has yielded. There's opportunity for a rebuttal from the, but not question and answers. You may take the mic. And anyone else also can do that. And again, we are going to keep this to 3 minutes at this point.
Mr. Chair, you should make it clear the rebuttal is for the information that was presented during the rebuttal.
Noted. So just to reiterate that, with the points that Attorney Kersadian brought up is what we need to focus the rebuttal on.
Sure. Again, for the record, I'm Linda Lasky, here with Christopher McKenna. And just in response to Attorney Kersadian's comments, the board will have the opportunity to look at Johnson versus ZBA. I feel it's directly, squarely on point. The issue is that in that case, there was a finding that there was no approved subdivision map, and so a lot that was on a map prior to subdivision regulations could not be used for a house. That's exactly the situation here. His comment that property owners need to know what they can do with their properties, that somehow justifies allowing undersized parcels to be used for a building lot. I don't see the logical connection there. The issue is whether a lot is an existing, non-conforming building lot for a specific purpose for building a house, and that may continue. And if it doesn't comply with all the zoning standards, then it can't be used for a new residential building lot. So also the fact that you can consolidate lots and that there's a lot merger provision does not mean that once you merge any two parcels, the resulting merged parcel becomes a lot for purposes of building. There's just no logical connection there, and there's no provision for that in the zoning regulations. Merger doesn't create a lot. It just creates two parcels if they don't comply as a consolidated piece. On the issue of the gazebo is a structure, certainly, but it is not a dwelling use. And It would be my understanding that a gazebo could potentially be appropriate as an accessory structure to the existing legally non-conforming dock use. The fact that a gazebo was built there doesn't then mean that you need to extend that to a house, and it's certainly not a house of the size and height of the one that's proposed. It's just completely outside the scope of any existing use or structure. On the issue of, this is somehow unfairly preventing people from doing other things on their lot or changing the use on the lot, well, that's exactly what the variance procedure is for. Variances under 8-6 and under your zoning regulations are put in place specifically to relieve hardship when zoning regulations are unfairly strict and they prevent reasonable use of property. That's exactly what they're for. So if the city is approving undersized lots as a matter of course, then I would submit that should be re-examined as a policy, because other towns do regularly use their variance procedures in coastal communities to ensure that there are public hearings so that the interests of all affected neighbors can be heard, and that any decision accommodates and recognizes the impacts on the neighbors, and also kind of the inconsistency with the comprehensive plan that's embodied in your zoning regulations. That is just something that is there when you have an undersized lot. It's not conforming, it's not consistent, it's not harmonious with your plan, and any deviation from that should be addressed through the variance process that gives everybody a fair say and is only available in case of true hardship. So the fact that you can't change a use without getting a variance is not unfair, it's the law. It's a matter of fairness. And I think that's all I have. Thank you.
I just had one thing. Mr. Saharides, you're spot on with this. Article 6 is the non-conforming use, structures, and lots. And the regulations state that they're supposed to, under 6.1.4, issue a certificate of zoning compliance. If all this information is just in the office of the zoning and the zoning office, we have no idea what they're doing. Nobody puts anything on paper. How am I supposed to refute that it's a legal building lot when, the zoning officer says it's okay? I think we need to put stuff on paper. They need to go out and do the research. They need to do their job, and then we could, maybe get to the right point.
Thank you.
Thank you.
Any member of the public like to address specifically what Attorney Kersadian presented in his rebuttal? Seeing none, you have the last word before we continue.
Thank you. So when you look at Article 6, non-conforming uses, structures, and lots, Section 6.2, 1, enlargement, extension, or alteration. No non-conforming use of land shall be enlarged, extended, or altered, and no structure devoted shall be enlarged, extended, constructed, reconstructed, or structurally altered, except in changing the use to one which is allowable in the zoning district. This is a single-family zone. This is a single-family house. Except in the case of single-family homes. And that language means that you can have a single-family home, or that it can be enlarged beyond what the original non-conforming structure was. So there's really two things to look at. It's a lot, it's a building lot, it's been issued building permits on it. Once it's a building lot, you can use it for whatever use is allowed in the zone, which in this case is a single-family zone, as long as you meet the zoning bulk requirements for setback and coverage, and what you're looking at is the structure over the 35-foot height limit and all of those other aspects to it. So we don't need a use variance. I don't even know if the Milford ZBA grants use variances. They grant variances for setbacks and other general issues is kind of the run-of-the-mill type of stuff that they grant. but we don't need a use variance. Just before I finish, there's also a definition, Article 11, legal non-conforming lot. Any lot legally existing in accordance with the then applicable regulations which has been made non-conforming by subsequent adoption of the zoning regulations or amendments thereof. So these lots were in place when the original regulations were adopted. They became non-conforming, and then over time, by function of 6.4.2 or lot consolidation, or they merged by use, or there was a map that was filed showing them, or the owner's intent was that it would be one building lot, it becomes a single lot. And once we're not asking for a subdivision. If we were asking for a subdivision, we would have to meet the 12,500 square foot requirement. So, thank you.
Okay, thank you. Is there, anybody think that we should act on this now, or should we take all this information that we have and read some more about some of the material we've been given? Mr. Sadi.
Thank you very much, Chairman Quish. I think there's been some comment about another commission that has happened. I think Attorney Crusaden talked about this, that they're not going to be meeting until March, the end of March, and maybe if you, through Mr. Sokas, we can give us some guidance about whether if we do something today, if that's going to be impacted or can impact them.
So the Harbor Commission, I guess the question would be if they came in with some adverse determination, what would that do to any action we took today?
Excuse me, who decided that there was an adverse determination?
I said if. I said what if? The Harbor Commission, who has a responsibility to look at this, how would that affect if we did something tonight? That was just my question.
But Mr. Chairman, what are they going to be looking at that hasn't been done already by the applicant?
I have no idea. I just know that they are required to look at it. And
Hello, I can fill you in. So there's a state statute that says that when the city or anyone does something within a certain radius of the harbor, that if the Harbor Commission asks, in this case, this is a CAM application, if the Harbor Commission asks for the CAM application, they can look at it and provide you with some guidance. So earlier in the evening, it was mentioned that the Harbor Commission did make that request, I'm going to say several weeks ago. They have been provided with the CAM, and then they are taking up that issue at their meeting, which I think is at the end of the third week of March. If they approve it, then it has no effect on this board. If for some reason they deny it, then this board would be required to have 2/3 of you would have to approve it. So that would be 7 of you to approve the application. That's the difference.
so, Mr. Satter, are you saying it's prudent to wait?
No, I'm just trying to get as much information for I do. So if make a decision tonight, it doesn't make any difference what the Harbor Commission does, because we already made a decision.
Yeah, you could argue that.
Well, I think that it would, if we did not have 7 votes in favor and they came out against it, then our approval would be null and void.
I would defer that to the attorneys.
Okay, so I would say that we don't have enough information at this point, and we should take into consideration what we've heard tonight, what we can review from the record on MGAT, and what we can read on the material that we were given. And the question then would be, do we keep the public hearing open, or do we close the public hearing and just...
I think that's an easy one, Jim.
Yeah.
I think let's close this public hearing.
You think?
And before you close?
No, I'm sorry, the public cannot speak at this point. Sorry.
And Mr. Chair, just for the record, because I've been instructed to let you know and to remind the board that this is a CAM application. This isn't about the history of the property, where it came from, any...
Well, I think there's differences of opinion on that too, David, to be honest with you.
I'm just letting you know what
I know,
I have been
I know.
told to let you know, for the
Yep.
record.
No,
So
very good.
This came to you as a CAM application.
Okay.
That's all I'm saying.
Very good. Okay, so what we will do is we will close the public hearing, and we will continue this till we get the harbor report. And at that point, we can have discussion amongst ourselves and questions to staff for clarification.
If you close the public hearing is closed. The only thing that I would report to you after the Harbor Commission is what their vote was. That way, you know how that affects your vote.
Right, and so then, but we could discuss this amongst ourselves at the next meeting. Yep, Ethan.
So are we going to have a motion first to close the public hearing?
Yeah, I think we can probably get someone to make the motion.
I move that we close the public hearing.
Do we have a second?
I'll second it.
All those in favor?
Aye.
Aye. Opposed? Seeing none, public hearing is closed. We will continue this to a point in time when the Harbor Commission has made their determination.
Yeah, for your planning purposes, I believe you'll know for the first meeting in April.
Okay, thank you.
Mr. Chair, before we finish this up, the time clock is still running for this application. There's no pause because we've got to wait for the Harbor Commission. This is time running, so if we don't get to a vote before the certain date, which I still think is in June, my memory is if we don't vote on it, it's automatically accepted.
June is 3 months away. We have enough
I
time.
understand that, but I mean...
No, I need to make some corrections. So you just closed the public hearing tonight, so a new time clock starts. So I believe you have, I think it's 65 days to make the decision. So that's going to go way beyond April. And then even if for some reason there was a delay, some sort of issue that we couldn't get the applicant to give us an extension for, there is no automatic approval for a CAM.
Thank you very much.
Thank you. Okay, the public, you're done. If you would, we do have other business, so if you would kind of move on quietly. No good deed goes unpunished. So just so the members know, we do have material down at the end of this table for you to bring and read if you'd like. It's been submitted and accepted as part of the record, so it's there if you'd like to get it. Our next order of business is old business, and this is sort of new old business, but it will be a standing agenda item. And we can give it as much or as little attention as the board wants, but we've had the Regulations Subcommittee going on for the last 6 or 7 years, and it's been suggested that maybe we make it a broader, make it more inclusive to the whole board. So what we're going to do is we're going to have an open discussion on anything that any member wants to bring up. If we feel there's a gap in our regulations, something that needs to be changed, we want to improve MCDD zone or the CDD3, or there's a particular gap in what we think is for the best good of Milford, then we're going to have that discussion. And at that point, anything that receives a majority vote will be sent to the Regulations Subcommittee for further research. We did just have, skipping over to the subcommittee reports, we did have someone come in and talk to us about affordable housing at our last Regulations Subcommittee meeting. And, that is something that you can see. Yep, Brian. You know what, is that, I don't remember his name. Rich?
That was David Fink, who is, okay, so I don't need to, okay.
Yeah. So we do have minutes of that meeting, and I believe that's recorded on MGAT for people to, refresh on. I'm not expecting necessarily anybody needs to bring anything up specifically for this meeting. I just wanted to introduce the concept and, give everybody an opportunity to think about it. And if there's ideas, we'll have them. I'll take anybody wants to share it now, it's fine. But I'm not really expecting, I'm putting any pressure.
Thank you. I want to recognize your leadership on this issue. It's something that seems a little bit different because we had always going with two subcommittees, and I know that some members had suggested this. I think it's a great idea. I brought up two areas I thought that we should really be looking at. One is a reassessment of the ADUs that we approved sometime in the past, and I suggested, I had a conversation with Mr. Solkis to try to get some numbers and ideas, but certainly we know that several members of the board ran for re-election this year, and affordable housing is certainly something we have to decide and work the best we can because the moratorium is no longer with us. But those are two other areas I thought were very important, and I suggest that your idea, along with the other members of the board, is an excellent approach to handling the planning portion of what we do. But thank you, and the other members that thought of this before me.
Yeah, thank you. So the ADU issue is that we did approve something, but it was approved only in an existing building or in addition to an existing primary use, not a accessory building that you could use as an accessory dwelling unit. Fairfield, for example, did it differently. A number of cities did it differently. We had a vote. We voted for it, but doesn't mean we can't bring it up again, discuss it, and change it as we go down the road. Is there anybody that has any thoughts or directions that we might want to go in? Etan?
Yeah, is there an issue, or has anybody indicated to you that there's an issue with our ADU? Because we just passed this last year, or 2 years ago.
There's a lot of interest in having Milford allow ADUs to be in a separate building on the lot, not necessarily just inside the building. We approved it to be inside the existing.
Inside the enclosed structure, not have a separate
Yeah,
structure.
so like
yes.
like in Fairfield, you could convert a garage, for example, if it met the other requirements, like a detached garage. But in Milford, you could not do that.
Okay, and so who has, if anybody, has been complaining about this or made note of this?
I don't really know that it's an individual that complained. Mr. Sadi has said that he feels that we should revisit it. We have new members of the board. We would also have another, if it's a language change, it would be another public hearing. So that would be another opportunity for the public to speak. So it's just, it doesn't mean we're changing it. It means we're open to, we could follow that road, and if it changes, it changes, based on the group voting for it. But if you see something in a particular zone or a particular language that you feel is inadequate in our regs, I mean, I'm sure that...
Yeah, and that's fair, but again, we spent a lot of time on the ADU regulations, and we kicked that thing around for a long time, and I'm not sure where this is coming from, where we need to now take another look at it, but that's fine, that's our job, and that's okay.
Okay, thanks. Yep, Mr. Sadi.
Through you to Commissioner Hirsch, it was my thought to go to the next step because we have to try to decide where can we find affordable housing. And I don't think we had heard about what happened in Fairfield. This is part of the meeting last week. But again, I'm not asking us to change it. I'm just saying it's something we should consider. We have to find ways to get affordable housing. Otherwise, we'll never meet our 10% because we're approving 200 buildings and 6 of them are affordable housing. We're never going to get to the moratorium. So again, we're just trying to keep up ideas. I'm not asking any specific change yet. And I agree there was a lot of work done on that. You certainly helped on that work, but that's the point of it. We have to try to find a way to get to affordable housing to make it more livable for people to stay in the city of Milford or to move into the city of Milford. That's why we are there. That's my explanation for it, and thank you very much for asking the question.
Good. Anybody want to weigh in at this point, or should we?
I agree with Eton. We spent a lot of time on it last year. I don't know why we have to do it again.
We don't have to. We don't have to. I mean, it's just something we bring up, and if we all want to do it, the majority of us want to do it, then we do it. If we don't have a majority, then we don't, and we do something else. If we find, there's a lot of interest in one particular building downtown Milford, maybe we revisit the Milford Center Design District and say, okay, we feel the heat from the public, and we would like to put some more restrictions on what we do with these old buildings. I'm not saying we should, but we could. We can revisit affordable housing and come up with a formula to require all multifamily housing projects to have some affordability. And so, if we can talk about that. I came up with a proposal, in a sense, like a spreadsheet to just look at it, and I'll put it on the agenda for next meeting, and we can discuss it and see if that makes sense. And at one point, we can bring in experts to talk to us about it in this particular agenda item, to talk to us about whether it's affordable housing or whether it's how do you change strip malls into residential, or whatever we feel is important. It's not only housing, but we do have these office district, huge amount of property that is fallow because there's not enough office space renters out there. So we could get ahead of the curve, and instead of getting applications kind of focusing what the applicant wants, we can sort of grab a hold of it in a bigger way and lead rather than follow. So I think if we all put our heads together, we can make some improvements for Milford.
One thing I'm concerned about is we need to find ways to incentivize developers to look into stuff like this. So I don't know whether we could bring in people that could discuss, that could speak to that, or
could you say that again? My earpiece fell off.
Incentivizing developers towards doing things along these lines. I don't know whether we could bring in experts who could speak to that, or
Yeah, it's a good idea. We could bring in some public, and then we could also bring in some developers to see what would be a carrot they'd like and what would be a stick they wouldn't like. Thank you.
Forgive me.
Yes.
I would very much like to discuss some of the things you mentioned up, an inclusionary percentage for all multifamily housing, the mixed-use districts. I think given that we have limited membership on the regulation subcommittee, but we are all members of the planning board, I think it's good for us to have conversations all together about these ideas. And given that I'm a new member, I wasn't involved in anything to do with the ADUs or anything that was worked on over the last year. I know there a ton of work went into it, but I think it would be really helpful and constructive. So thank you.
All right. Brian.
I don't consider myself an expert in housing. However, I did serve as the liaison for the city, for the mayor, appointed by the mayor, I should say, to the regional body on the issue of housing. I'm a former housing authority director, and I've spent a good part of my career on housing and economic development issues. I've long believed that as a city, as opposed to having developers determine where they're going to put projects, the city needs to be taking a much more assertive position where you open the doors to any potential developers, hold a charrette, hold discussions about where it is we would like to see projects being built. And the city could be taking an active role in identifying properties, and I believe that that's been done to an extent up to now. They did the drive-by survey, et cetera. But it could be a very different future than what we've experienced in the past.
Good. Yeah, I think those are good observations. And if there are documents that you feel we should all sort of absorbed somehow. If we could get that as staff to provide them for us, if there's been certain studies, I know there's been some, but get us ready for the next meeting, and we'll put housing on, in terms of regulation changes, an open discussion on housing for the next meeting, and we'll listen to Joe Griffith. Yeah, that's a good idea. And if, again, did you provide that link to everybody already, David?
I can provide a link to everybody.
Okay.
As well as not just the subcommittee link, but I got today, which I did give to the subcommittee, a link to the Council of Governments Housing Task Force housing group, which David Fink also hosted at the Council of Governments, which they had developers come and talk to them about, it was a roundtable, what kinds of things work for them, what kinds of things don't work for them. And I'll provide that to everyone on the board as well, because that dovetails in with some of the comments that were made here this evening, as well as obviously the topic.
Okay, that's great. So that would be our homework. So I think first thing is, it's a big issue. It'll probably be on more than one meeting, but let's put that on as what we're going to do for old business regulations changes for the next meeting. And if anyone, wants to bring something else up to put in queue, just let us know and we'll put it in queue. We want it so it's not overwhelming one particular meeting, but we'll get it listed and in the backlog. Chair's report, I have nothing. Oh, no, approval of minutes. Do we have a motion? Motion, second. All those in favor? Aye. Opposed? Seeing none, it's approved. No report for the chair, staff?
Nothing this evening.
Thank you. We're adjourned. Oh, liaison reports, excuse me.
Thank you. I attended last month's meeting, the Regional Council of Governments that I represent this particular wonderful board, nothing affecting us. We're coming up next Thursday. I'll see if there's anything else, but it's supposed to be 7 members of the agenda. But thank you, Mr. Chair.
Thank you so much. All right, we're done. Thank you.